In this video, I want to look at the International Court of Justice. It's one of the 6 principal organs of the United Nations system. And according to here, this is the Charter, Article 7. There are established as principal organs of the UN, General Assembly, Security Council, Economic Social Council, Trusteeship Council, an International Court of Justice, and a Secretariat. I think I touched upon all of the principal organs except for this one. So I was going to look at this one, and I want to look at it in conjunction with this application instituting proceedings, which was filed on December 29th, 2023. It was filed by South Africa against the State of Israel, and it has to do with the recent strife, turmoil that's affecting that area of the world right now. And a big part of the video is we're going to take a look at the application for South Africa filed, and we're going to compare it with another application that was filed back in 2019. And this one is the Gambia versus Myanmar. And I'm going to do a side-by-side comparison, and I think that's going to give us a good indication. We're going to take a look at the order from the ICJ in the Gambia case, and then we'll use that to predict how the ICJ is going to rule in the South Africa-Israel case. So the subject matter of the application, it says it concerns acts threatened, adopted, condoned, taken, and being taken by the government and military of the State of Israel against the Palestinian people, a distinct national, racial, and ethnical group, in the wake of the attacks in Israel on 7 October 2023. So the application says that it's against the Palestinian people, a distinct national, racial, ethnical group. And so where do the Palestinian people live? The paragraph here, 21, talks about it a little bit. We'll take a look here. Gaza itself is a narrow strip of land bordered to the west by the Mediterranean Sea, to the south by Egypt, to the north and east by Israel. Together with the West Bank, including East Jerusalem, it is one of the 2 constituent territories of the occupied Palestinian territory, occupied by Israel in 1967, and of the State of Palestine, recognized by South Africa 1995, and accorded non-member observer state status in the UN in November 2012. So let's just take a look. Let's get our bearings here, see where it is located on the globe. We shoot over to the Mediterranean. Here is Gaza, and it is this area here, bordered in red. And that also includes, they're including the West Bank as well, which is here, the west side of the Jordan River and the Dead Sea. This area here. So the Palestinian people are located in these 2 territories. And we pull back a little bit more. Let's get an idea of the region. We're looking at the Middle East. Here is Jordan, Syria, Lebanon, and over here is Egypt. We've got Africa, Mediterranean, Turkey, Greece, Italy. So this is the region we're talking about today. All right, let's talk more about the International Court of Justice. If we look at the chart here, we see that all of the organs, they have these subsidiary organs, except the International Court of Justice and the Trusteeship Council. The Trusteeship Council is no longer functioning, but the International Court of Justice is, and it doesn't have any subsidiary organs. So that kind of tells me that even though they're within the UN system, they kind of operate independent of the general day-to-day activities of the UN. And if we go over to the charter, we see, yes, it's listed as one of the principal organs. And then chapter 14, we've got the International Court of Justice, and It is declared to be the principal judicial organ, and that it functions in accordance with the annexed statute. So attached to the UN Charter is the statute of the International Court of Justice, and it forms a part of the Charter itself. All members of the UN are parties to the statute of the International Court of Justice. So along with your membership to the UN, you get a bonus to be a member of the International Court of Justice. Each member of the UN undertakes to comply with the decision of the ICJ in any case which it is a party. So if you're a party to a case, you have to comply with the decision. And if a party to a case fails to perform, then the recourse you have is that the other party can go to the Security Council. And as we know, the Security Council has a wide range of things that they can do, up to and including military action, if it deems that there is a danger to the maintenance of international peace and stability. All right, let's take a look at the annexed statute of the International Court of Justice. The court itself is composed of a body of independent judges, consists of 15 members. The members here are the judges, no two of whom may be nationals of the same state. The judges are elected by the General Assembly and by the Security Council, nominated by the national groups in the Permanent Court of Arbitration. So you have another separate entity organization called the Permanent Court of Arbitration, and I have it up here. And the members of the court are potential arbitrators appointed by the contracting parties. So there's like 120 some odd contracting parties. They then nominate members of the court, and then the members of the court from each party, they constitute a national group, and it's that national group that nominates the judges, which are then put before the General Assembly, Security Council, and then they vote to see who the 15 judges will be for the ICJ. Just looking at some other relevant or significant articles of the statute. Members of the court shall be elected for 9 years and may be reelected. So that's a pretty good gig. No member of the court may exercise any political or administrative function or engage in any other occupation of a professional nature. So it's pretty much a full-time job. No member may participate in the decision of any case which he has previously taken part as agent, counsel, or advocate for one of the parties. So make sure that there's no conflict of interest, and that's self-governing. Every member of the court shall make a solemn declaration in open court that he will exercise his powers impartially and conscientiously. So that's the oath of office: impartiality, conscientiously. And a couple more. If the court includes upon the bench no judge of the nationality of the parties, each of the parties may proceed to choose a judge as provided in paragraph 2 of this article. So in our case, in the South Africa and Israel case, the members of the court, the 15 ICJ judges, none of them are members of South Africa or Israel. So each party, both South Africa and the State of Israel, they each get to choose a judge of their choosing, and they have to be among those persons who are nominated. So in this case, there's actually not 15 judges, but 17 judges. The original members of the court plus 2 judges, which they call them ad hoc judges. There are 2 ad hoc judges, one appointed by South Africa and one appointed by Israel. So 17 judges will be voting on this case. And I think that's the only. The court shall have the power to indicate, if it considers that circumstances so require, any provisional measures which ought to be taken to preserve the respective rights of either party. So provisional measures, actually, the government of the Republic of South Africa not only has it filed an application as a dispute, but it's also requested provisional measures And that's important, as we'll see later in the video. And then finally, pending the final decision on the application itself, notice of the provisional measures suggested shall forthwith be given to the parties and to the Security Council. So even before there's a decision on the merits of the case, there's actually a separate proceeding. In this case, South Africa has requested those provisional measures. So it's kind of like in U.S. we call it maybe a temporary injunction. So that proceeding, once that proceeding is complete, the ruling on that will be given to the Security Council. So that's important because the Security Council can then act. And that's the only ones that I highlighted to discuss. All right, before getting into the application, we'll take a look at the ICJ in action. Here is a video of a hearing that took place January 12th, and it was on Israel's presentation of the case after South Africa went. And so let's look at this, and then we'll take a look at the application.
Please be seated. The sitting is open. The court meets this morning to hear the State of Israel present its single round of oral argument on the request for the indication of provisional measures submitted by the Republic of South Africa on 29 December 2023 in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip, South Africa versus Israel. I shall now give the floor to the co-agent of Israel, Mr. Tal Becker. You have the floor, Excellency.
Madam President, distinguished members of the court.
All right, let's get into the application itself. Here it says, in accordance with Articles 36 of the statute, we're submitting this application against Israel. It also requests that the court indicate provisional measures. Another relevant part, Israel's acts and omissions in relation to Palestinians violate the Genocide Convention. So the basis for this application has to do with Israel's violation of the Genocide Convention. We'll take a look at that in a second. The jurisdiction of the court, they're both members of the United Nations, therefore bound by the statute of the court. And they're also parties to the Genocide Convention. We'll just assume that the court has jurisdiction. No need to get into that. Israel has dismissed as outrageous and false the assertion that Israel's military attacks on Gaza meet the legal definition of genocide and are aimed at not just simply the killing of innocent people, destruction of livelihoods, but systematic effort to empty Gaza. So Israel has already publicly said that this is that it does not meet the legal definition of genocide. Gaza Strip, we already talked about that. And let's see what other things I highlighted. The Israeli president has invoked the right of self-defense as justification for Israel's ongoing military activities in Gaza. And why is that important? It's because we have in the UN Charter itself, Article 51, where it says that nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the UN until the Security Council has taken measures necessary to maintain international peace and security. So right there, Israel is already invoking that right, which may trump the UN, anything having to do with this application. And furthermore, what else do we have highlighted? We also have here, so in the application itself, South Africa has put forth all this evidence that Israel has the requisite intent to commit genocide, which is important because the Genocide Convention itself, right here, it has the element of intent. Intent is required in order to violate the Convention on the Prevention and Punishment of the Crime of Genocide, with intent to destroy, in whole or in part, a national, ethnical, racial, or religious group. So South Africa goes into a lot of the intent that they're saying Israel does have the intent. And then we've got, here are the South Africa then just lays out the different violations failing to prevent genocide, as in Article 1. Article 1 here says that all the parties must undertake to prevent genocide, and they have not done that. Article 3A and 3B is 3A, the following acts shall be punishable: genocide. And genocide is any of these acts with the intent, killing members of the group. You can do, and also conspiracy is a violation. Furthermore, we've got, okay, so here are the requests for provisional measures. As I said, this is a separate proceeding. South Africa has requested these provisional measures, and more specifically, they want to protect, preserve those rights as well as its own rights under the convention, prevent any aggravation or extension of the dispute, pending the determination of the merits of the issues raised. So let's have this first initial proceeding to discuss provisional measures, where South Africa will see in a second what they request the court to do before we even get into the case. And then South Africa says, well, that according to established law in the ICJ, we are not required to ascertain whether any of the violations, whether any violation of Israel's obligation has occurred. So we don't even have to get into whether the acts of genocide occurred, whether Israel had the intent. All we have to do is, it says here, anything that's, if it's capable of falling within the provisions of the Genocide Convention. And more specifically, it says whether that the court only need to decide whether it has satisfied the rights asserted by South America, which is seeking protection, whether they are at least plausible. That's it. So with all the evidence that South Africa presents, they have video evidence, they have testimony, and they're probably going to meet this standard where they can show that it's at least plausible that the acts did occur. And then what else we have? So here are those provisional measures that South Africa has requested. Israel shall immediately suspend its military operations in and against Gaza, take no steps in furtherance of the military operations referred to one above, take all reasonable measures within their power to prevent genocide, desist from the commission of any of all acts, take all measures within its power, including the rescinding of relevant orders. So for Israel, do not commit any acts, and then preserve evidence, and then shall submit a report to the court on all measures taken to give effect within 1 week, and Israel shall refrain from any action should no action is taken which might aggravate or extend the dispute. So, all right, let's start doing a side-by-side comparison. On this side of the screen, the left side of the screen, I've got the Gambia, Myanmar application. On the right side is the South Africa, Israel. So on the left side, we have the older application, and on the right side is the newer one. So starting with the opening paragraph, we have, looks like the Gambia was the applicant, and they cited Articles 36, 1, and 40 of the Statute of the Court, and also Article 38 of the Rules of the Court. And on the Israel side, we also have the same exact citation of law, Article 36, 1, 40 of the Statute of the Court, 38 of the Rules of Court. And then the introduction, the Gambia one, we've got the identification of the group of people which has genocide threatened upon them, and that's the Rohingya group. They claim to be a distinct ethnic, racial, religious group that resides primarily in Myanmar. And then in the South Africa application, we've got the application concerns acts threatened adopted against the Palestinian people, a distinct national, racial, ethnical group. And then if we look real quick in Wikipedia, Rohingya people, the total population is between 1.5 and 2 million. Palestinian people, 14 million. All right, the next part of the application is the allegations supporting the claim of genocide. In paragraph 4 of the South Africa application, Israel has now killed in excess of 21,000 Palestinians, including children, 7,000 missing, presumed dead, damaging homes. And then going to the Gambia application, it doesn't seem to be a cumulative number that the Gambia has calculated. I guess that's probably from the fact that the Rohingya people don't really have any type of government or any agencies, but they did create the United Nations Security Council created the UN Human Rights Council's independent international fact-finding mission on Myanmar, and the conclusions of that report says September 2019 report confirmed its earlier conclusion that Myanmar is responsible for the commission of genocide. It found the evidence infers genocidal intent. And then they also have many instances, separate witness events or events that witnesses have seen, and they document it. And so that is the facts behind the Gambia's application for genocide. Next, we go into the claims of South Africa and the claims of the Gambia. They're pretty much identical: committing genocide, conspiracy to commit, failing to prevent. They're all of pretty much the same. And now we go into the relief sought. So here's the applicant. What is it that they want the court to do? And South Africa wants the court to adjudge and declare that the state of Israel has breached and continues to breach its obligations under the Genocide Convention. And then you'll see the Gambia one is just about identical, if not identical. That Gambia requests that the court adjudge and declare that Myanmar has breached and continues to breach its obligations under the Genocide Convention, and more specifically these articles, which are pretty much the same in the South Africa application. Okay, so that's the application, and that's the relief sought in the application, and that concerns the case as a whole. But in both applications, the applicants are requesting these extraordinary measures, a separate procedure, and that is called provisional measures. Here is the Gambia's request for provisional measures, and here is South Africa's request for provisional measures. And this is where it gets a little bit more dire. This is actually something that the court, you may see something that the court may do in a more near term. The application itself, that could take 5-8 years, but the request for provisional measures is something that probably can happen in the near term, maybe within a year. So the request for provisional measures is when you're asking the court to step in and maybe order one or more of the parties to perform some positive act or refrain from certain conduct. And that is actually the authority for that is here in the statute of the International Court of Justice in Article 41, where it says that the court shall have the power to indicate, if it considers that circumstances so require, any provisional measures which ought to be taken to preserve the respective rights of either party. And pending the final decision, that would be the final decision on the application itself, notice of the measures suggested shall forthwith be given to the parties and to the Security Council. So the Security Council is the one that's actually going to enforce those provisional measures that the ICJ may order. And going back to the application, here we see that they have to show that provisional measures are needed in this case, that the respective rights of the party are being violated, and that the court has to do something to make sure that those rights are protected. And here they're saying in the Gambia one, compelling circumstances require. There's lots of killing and other violence on the Rohingya people. And in the South Africa case, that showing is also made by the applicant. All right, and here are the provisional measures requested. The Gambia requests that Myanmar take all measures within its power to prevent all acts that amount to the crime of genocide. All its military do not commit any act of genocide. This is what they're asking the court to order: that Myanmar shall not destroy or render inaccessible any evidence, shall not take any action, shall ensure that no action is taken which may aggravate or extend the existing dispute, and that both parties, Myanmar and Gambia, shall provide a report to the court on all measures. And then in the South Africa one, it's pretty much the same, except South Africa goes into a little bit more detail. State of Israel shall immediately suspend its military operations, take no steps in furtherance of the military operations, take all reasonable measures within their power to prevent genocide, desist from the commission of any and all acts within the scope of Article 2 of the Convention, killing members of the group, take all measures within its power, including the rescinding of relevant orders, restrictions, and or prohibitions to prevent the expulsion, deprivation, do not commit any acts described in 4 and 5 regarding genocide, preservation of evidence, which is in the Gambia, shall submit a report to the court on all measures, shall refrain from any action, shall ensure no action is taken which may aggravate or extend the dispute. So pretty similar. A lot of the same phrases are used, except the South Africa one goes into a little bit more detail. All right, now let's talk about the order on that application for provisional measures. The application was signed November 11th, 2019. The order came out January of 2020, so a little bit over 2 months. And the court here then goes through the provisional measures that were requested, and then it goes on to talk about the standard that it's going to use to decide the case. First it goes into the jurisdiction and says both parties are members of the Genocide Convention, so it has jurisdiction. And then here is the standard which the court is going to use, and that is whether the rights claimed by the applicant and for which it is seeking protection is it plausible? Is it plausible that the acts occurred, and if so, are those rights protected? Is it plausible that those rights are protected? And there it then restates it again, plausible, and then it also is going to decide whether there's a link between the rights claimed and the provisional measures requested. And then it also has to determine whether there's irreparable prejudice, and if there's a real and imminent risk that the irreparable prejudice will be caused before the court gives its final decision on the application. And then finally, the court does find that there is a real and imminent risk of irreparable prejudice to the rights invoked by the applicant. And then it also says that the court concludes that the conditions required by its statutes for it indicate provisional measures are met. And then the court then says that, it's going to issue an order requiring the following provisional measures. And it's pretty much everything that the Gambia asked for. Take all measures within its power to prevent the commission of all acts, do not commit any of the acts, take effective measures to prevent the destruction, ensure preservation of evidence, and that Myanmar has to submit a report to the court on all measures taken within 4 months. So now, with that in mind, how does that help us predict what's going to happen in the Israel case? This is the application signed by South Africa, signed on December 28th, 2023. And so this application itself, it seems to have all of the same elements of the Gambia case. The facts are there of the danger, the harm that's happening to the people. You've got the Genocide Convention, which was cited as the basis for the jurisdiction in both cases. You've got the request for provisional measures in both cases, and the request for provisional measures is pretty much identical in the same case in both cases. So it's looking like within 2 months, probably late February, you're going to see an order from the ICJ awarding provisional measures in this case against Israel, and much to the same that they did with the Gambia. They're going to have to take steps to stop all military activity. They're going to have to make sure that they preserve all evidence, and they're going to have to submit a report as well to the court, and eventually it'll go to the Security Council. And so the provisional measures here will go to the Security Council, and now that would be the next step. Will the Security Council ensure that those steps are taking place? If the Security Council sees that Israel is not doing any of the things mentioned in the ICJ order, what does the Security Council do? And of course, you've got the potential for vetoes in the case. So we'll see. Hopefully I will update on this channel a new video with the actual order from the ICJ in February.